Today we're here with Gibbons, CEO of Bennett Carroll Solicitors. Hi Guy, how are you?
Good.
That's good. Guy, just a few things about wills and estates. How do I contest a will?
Okay, well there are essentially two branches of argument about a will. The first is that the will is not correctly executed. So there's a protocol, a requirement, a formal process for executing the will correctly, and it might be that it hasn't been executed properly. So that's the first, it's 1A if you like. The state government has lowered the bar on that a little bit over the last few years, and they'll accept a certain amount of non-conformity on that. 1B, by far the more common argument, is that the person that signed that will doesn't have what's called testamentary capacity. Doesn't have their marbles in effect. The argument being that they didn't sufficiently understand the nature and effect of the document to adopt it and to adopt the contents. So this is becoming increasingly common with all of us living longer, with medication keeping us alive but affecting our decision-making capacity, and with diseases such as Parkinson's, which affect you at different times of the day depending upon what medication you're taking. So that's the first limb of argument, is that there's something wrong with the document itself. The second limb of the first way, option 1B if you like, is to argue that the person that signed the document didn't have the capacity, what we call testamentary capacity, didn't have their marbles, essentially didn't understand the nature and effect of that document sufficient to be able to know what was going to happen with it. And that is increasingly common, an argument these days. We're all living longer, and medication is keeping us alive and healthy, but it's affecting our decision making, and this is becoming a fairly hot topic. So testamentary capacity is a more common argument these days, as is an emerging area called undue influence. Now, undue influence wasn't much of an issue 10 or 15 years ago, but it's now being argued increasingly commonly that somebody has been influenced to make a particular decision in their will, to leave money or not leave money, to leave their assets in a particular way by somebody who's close to them. And this is an argument we're seeing more and more being made. We'll go into that in a little bit more detail. But that's the first bunch of arguments that are made. The second bunch of arguments, by far more common by number and more successful by number, is what's called an application for provision. It's effectively where somebody goes to the court and says, look, yes, the will is valid and it encompasses the wishes of the person that made it, but it's not fair. I've not been written, I've been dealt with unfairly. Now, the commonly held perception, and largely true, is that your assets belong to you and you can leave them wherever you like. But the legislature of each state, the Parliament, has set up an obligation for people to provide for their immediate family. So, unless there's a particular reason for, say, a child to be left out, the court will assume or will require, as a result of the Parliament, will require some provision to be made for that child, unless there's a good reason. So it's open for the child to go to the court and say, look, there are three of us, the other two are getting everything, I'm getting nothing, this is unfair. And there are about a dozen different criteria that the court will apply to see whether they should rewrite that will. If the will is clear and it has a very clear statement of intention about, for example, providing less for a child and explains why, then a court probably won't intervene and change that. And there can be some very good examples or very good reasons why that's appropriate. For example, if you've got 3 children and you made a significant gift whilst you were alive to one of those children, if one child has had a great deal of benefit whilst you were alive, it may be appropriate, or it's open to you, to say, well, I've already done well for that child, I'm going to favour the other two. And if there's a proper explanation and sufficient information available about that, then the court won't interfere. But they look at a whole range of criteria, and unfortunately it's not a mathematic formula. The court reserves the right to look at each matter on its own facts and to make what seem like varying determinations. The criteria are, broadly, what was the relationship between parent and child in an interpersonal sense? Did one support the other? Did the child support the parent? Did the parent support the child? Did they have a monetary relationship? Was one loaning money to the other, vice versa? Was there what the court rather acutely calls disentitling behaviour? In other words, has one of them been a rat bag towards the other? And that cuts both ways in many family relationships. So all of that information is looked at by the court. They look at the capabilities of the estate, in other words, how large is the estate, the size of the estate is a criteria. They look at the needs of the applicant child and the needs of all of the other affected parties. There might be there might be a number of other beneficiaries. There might be 8, 9, 10 beneficiaries in some states who are not necessarily children. But if they've been provided for in the will, and if a change by the court is going to affect their entitlement, then they are interested parties. So before we leave that subject, Tanya, we should just talk about the time limits for an application for provision. Now, this legislation is state-based, so each state has its own, and the time limits are slightly different, but they're all rather short. In Queensland, you have to give a formal notice that you intend to bring an application within 6 months after the date of death, and then you have a further 3 months, so a total of 9, to actually lodge that application. If you don't, then you lose those rights. You can theoretically apply to the court for leave to get back through that door, but it's not easy. So you really have to be pretty diligent, get some advice, make up your mind that you're ready to go through this process, check what prospects you've got, and then get on with it fairly quickly.
Okay, thank you.